Mr Greenie, good morning.
Good morning, sir. The hearing has been listed today, initially also with the prospect of tomorrow also, to address three distinct issues. First, the primary purpose of the hearing was to enable you to hear argument about the process the inquiry proposes to adopt to the handling of operationally sensitive material, although, as I will explain, sir, that argument has dropped away, at least in very substantial part. Secondly, the hearing has been listed to enable the inquiry legal team to update you, the core participants and the general public about the scope of Chapter 3 of the inquiry's oral evidence hearings. And Chapter 3, as everyone knows, will address the events immediately surrounding the bombing and is due to commence on the 9th of March of next year. The third reason why the hearing has been listed, sir, is to enable the inquiry legal team to provide core participants and the public with an update about a number of procedural issues, but principally about disclosure. The order in which we propose to address those topics is this. I will make some short introductory remarks about the first topic, namely the approach to operationally sensitive material, and then Mr Pleath will develop the situation. Sir, this topic, the first topic, is an issue upon which we considered it appropriate to invite submissions from core participants. So once Mr Pleath has finished explaining the inquiry legal team's position on the first topic, we will ask core participants to make oral submissions on the issue, but on this issue only, if they continue to wish to do so. Once that stage of the hearing is reached, we will invite submissions in the following order. First of all, from Ms Fee on behalf of His Majesty's Government. Secondly, from Mr Henry on behalf of PS&I. Thirdly, from Ms Smith on behalf of the BBC. Fourth, from Mr Southey on behalf of the Foxlaw families and survivors. Fifth, from Mr Kane on behalf of those represented by John McBurney solicitors, now part of Anderson, Gillian Barr. Sixth, from Mr Mansfield on behalf of the Rush family, represented by Elevate Law. Seventh, from Mr McGuckin on behalf of Campbell and Hawhey, Roach McBride and P.A. Duffy. And finally, if any reply by the inquiry legal team is necessary, then I will reply. Once we've heard, sir, from core participants on the first topic, and once I have replied if necessary, Mr de la Pore will deal with topic 2, namely the outline of what Chapter 3 will cover. What he has to say today is for the purposes of information only, and we will not be inviting submissions on this second topic today. And then, finally, I will deal with topic 3, namely the provision of a brief procedural update. Again, this information provided today is provided for information only, and we will not be inviting submissions from core participants upon it. So, sir, the short introductory remarks on topic 1. The inquiry holds material on its open disclosure database that is relevant to your terms of reference and which therefore falls to be disclosed to all core participants, but which it is considered may not be capable of being made public without redaction of information within it that is operationally sensitive. As Mr Pleath will explain in a few moments, operationally sensitive material is material that is not so sensitive as to be said to be closed, but which does contain information which, if published, would be capable of assisting those who would wish to carry out future terrorist attacks or undertake other criminal activity. And so that line has been well understood and applied in other processes. The inquiry legal team considers that a mechanism needs to be put in place that achieves the following in relation to operationally sensitive material. First, it ensures that terrorists or other criminals who would wish us harm are not assisted. Second, it ensures that core participants receive the material without undue delay. And third, it respects the open justice principle. The inquiry legal team has proposed a three-stage approach which we consider achieves those three aims. Mr. Pleath will deal with the detail of that approach, which has widespread support from the bereaved families and survivors, and is no longer, as of last night and this morning, the subject of any objection, or certainly any substantial objection. In its initial written submissions, HMG expressed concerns about the proposed approach. However, we understand that HMG now accepts, at the very least in large part, that the approach proposed is one that achieves its aims and will work. So we're pleased that a solution has been reached. And it seems to us that whenever there is a potential disagreement with an approach proposed by the inquiry legal team, it is important that core participants work closely with us to see whether it can be resolved, and do so as early as possible, because that will enable the inquiry to remain focused on its core work and avoid distractions. In its submissions, PSNI did not challenge the overall process that we proposed, but made some constructive proposals of its own about the language used in relation to the categories of operationally sensitive material proposed by the inquiry legal team, and some other core participants supported the position adopted by PSNI. The inquiry legal team has reflected on the submissions of the police and has made some adjustments to the language used in relation to the categories as a result. And we now understand that any concerns that PSNI had initially have disappeared. Finally, the BBC had suggested that the press should be able to report contemporaneously on any operationally sensitive material that was heard during the course of a hearing. The position of the inquiry legal team was that to do so would defeat the very purpose of the approach we have suggested, and that its process provides appropriate protections for the legitimate and important interests of the press and the public in open justice. And Sir, Ms Smith has been good enough to explain to me this morning that the BBC does not now, in light of the further written submissions of the inquiry legal team, oppose the process that we propose, and we are grateful to them for the further consideration that they have given to our position. Given that the concerns of HMG and PSNI and of the BBC have been addressed, we doubt that many core participants or the media will have much to say orally this morning, and as a result we shall certainly conclude this hearing today, indeed well within the day. However, notwithstanding that agreement has broken out, we consider that it's important that Mr Pleath should explain the detail of what the process for handling operationally sensitive material will involve, and that is so that process should be understood publicly. Before inviting Mr Pleath to develop topic one, we consider it important to emphasise that the drive for the solution to the issue of operationally sensitive material and the work to achieve it has rested within the inquiry legal team's disclosure team, particularly Gabriella Quick and Niamh Fox. In simple terms, sir, they identified the issue and they also identified the solution. So having made those remarks, as I indicated, I'll now invite Mr Pleath to develop topic one.
Mr Pleath.
Good morning, sir. So, as Mr Greeny has explained, the inquiry holds on its open disclosure database material which is relevant to your terms of reference and therefore falls to be disclosed to all core participants, but which is not capable of being made public without redaction of information within it that is defined as operationally sensitive. By that phrase, operationally sensitive, we mean material containing information which, if published, would be capable of assisting those who would wish to carry out future terrorist attacks or other criminal activity. Examples of operationally sensitive material might include information which sets out details on how to build or maximize the effectiveness of an improvised explosive device, or information that explains techniques available to law enforcement agencies to disrupt the activities of those engaged in terrorist or other criminal activity. Faced with information falling within that category on our open disclosure database, we considered how we could facilitate the disclosure of that material to core participants. And we determined that it was essential that a practical process was established which ensured that the material was identified, handled fairly, and handled in such a way so as to avoid disproportionate delay to the substantive progress of your inquiry. We considered that it would be both impractical and would inevitably cause delay if core participants were required to make repeated line-by-line or individualized restriction order applications over such material. Such a process would take too long, and it would, we consider, interfere with the serious and substantial work which your terms of reference require. And it was, in our view, essential that a workable process was therefore developed. On the 1st of September, we published a note titled Interim Restriction Order, Operationally Sensitive Material. That note was accompanied by an interim operationally sensitive material restriction order, which you, sir, had issued pursuant to Section 19 of the Inquiries Act. That restriction order was necessary to facilitate the disclosure to core participants of a sample of operationally sensitive documents, and it also served a secondary purpose, demonstrating the proposed purpose and operation of a final operationally sensitive restriction order. And so, sir, at this hearing, we are inviting you to take two steps. First, to endorse the proposed process for handling and disclosing operationally sensitive material that we have set out in our note and submissions prepared in advance of this hearing. And second, to issue a final operationally sensitive restriction order which implements the proposed process. In our note, we established a timetable for core participants and for the media to file written submissions in relation to the proposed process. And in accordance with that timetable, we have received written submissions from most of the core participants as outlined by Mr. Greene and from the BBC. So in these oral submissions, I intend to address you on four core areas. First, the inquiry's commitment to openness. Second, the process of restriction orders generally, given, sir, that this is the first time that you are invited to consider issuing what might be described as a substantive restriction order. Third, an outline of the proposed process for identifying and disclosing operationally sensitive material, which is implemented through the operationally sensitive restriction order. And finally, sir, I propose to respond to the submissions received from some of the core participants, although, as Mr. Greene has alluded to, it does appear that some, if not all, of the government and BBC objections to this process are no longer being pursued. Nevertheless, we consider it appropriate to address these concerns publicly, given the derogation from complete openness that this operationally sensitive process would inevitably entail. Turning to the first of those topics, the inquiry's commitment to openness. As our note makes clear, this inquiry is committed to holding as much of its process as possible in public. Openness, so far as possible, is embedded in Section 18 of the Act and is a core component of the requirement in Section 17 for you, sir, to act fairly. That commitment to openness has been a guiding principle of this inquiry since it began, and was expressed in your 21st February 2024 statement on the terms of reference. But we recognise that this commitment to openness must be more than just words. It is and will be central to every aspect of this inquiry. We acknowledge that providing core participants with as much information as possible, involving the media, conducting public hearings, and acting with transparency are all essential to achieving that stated goal. Turning to the second of my topics, restriction orders generally. So as I've said, this is the first time that you are invited to issue a substantive restriction order in this inquiry. The relevant statutory provisions are outlined in our notes and can be summarised in short as follows. Section 17 provides that you determine the conduct and procedure of an inquiry. You must act with fairness and with regard to the need to avoid unnecessary cost. Section 18 provides the presumption that the inquiry will be held in public. And Section 19 provides the power for you to restrict public access to hearings or evidence where required by any statutory provision or rule of law, where conducive to the inquiry fulfilling its terms of reference, or where necessary in the public interest. And in determining whether a restriction order should be made, you are required to consider a number of factors set out in sections 19.4 and 19.5, including, so far as relevant to this inquiry, the extent to which any restriction on attendance, disclosure, or publication might inhibit the allaying of public concern, any risk of harm or damage that might be reduced by any such restriction, including that of death or injury, damage to national security, or damage to international relations, or the extent to which not imposing any particular restriction would likely cause delay or impair the efficiency or effectiveness of the inquiry, or otherwise result in additional cost. Turning then, sir, to the third topic of my submissions, the process for managing the disclosure and use of operationally sensitive material by core participants. And this process is, as Mr. Greene has alluded to, divided into 3 stages. Stage 1 relates to the identification of operationally sensitive material. Stage 2 relates to the disclosure of operationally sensitive material. Stage 3 relates to the use of operationally sensitive material at hearings. At stage 1, once a document is received by the inquiry onto our disclosure database and has been determined to be relevant by the inquiry legal team, we will assess on a provisional basis whether any content within that document is operationally sensitive, as defined by categories, which we are inviting you, sir, to endorse following this hearing. In our note explaining this process, we originally proposed that there should be 3 pre-approved categories of operationally sensitive material. We have carefully considered the submissions received from core participants and have, in light of those submissions, concluded that the difference between our originally proposed Category A and Category C is no longer significant or material, making the maintenance of that distinction unnecessary. Accordingly, sir, we propose and invite you to endorse the following 2 categories of operationally sensitive material. Category A, defined as tactics and capabilities used by the UK state authorities and others in the investigation and/or disruption of suspected terrorist or other criminal activities. And Category B, defined as methods and strategies used by individuals in the preparation and/or commission of suspected terrorist or other criminal activities. The original descriptor for old Category C material included the words, "that is not currently in the public domain." A number of submissions were made by core participants in relation to the challenges surrounding whether information is or is not in the public domain. And on reflection, we agree that these words may be difficult to apply in practice. Accordingly, these words are no longer proposed for inclusion in Category A, into which the old Category C has been merged. That said, it is important to emphasise that we nevertheless consider that a very relevant consideration as to whether or not material falls into any of the operationally sensitive categories is the degree to which there is already public awareness of that information. As such, we invite you in your ruling to endorse the principle that when consideration is being given at any stage to whether material is operationally sensitive, a relevant consideration is the degree to which there is already public awareness of that information. Turning back then, sir, to the process for identification of operationally sensitive material. Once the inquiry legal team has determined a document to be relevant, we will, as I say, assess on a provisional basis whether any content within it is operationally sensitive and which of those two categories applies. The material providers, meaning the entity which provided the documents, will then be invited to indicate in their review of material whether they agree with the inquiry legal team or whether they identify any further information within a document which is considered to be operationally sensitive, such that it requires provisional redaction. We envisage that following a period of constructive discussion, if any material provider's final position, is that information within a document is considered to be operationally sensitive, such that it requires provisional redaction, then that redaction will be applied before disclosure to core participants. In this way, core participants will not be delayed from seeing material any more than is absolutely necessary. This would be the case even where the inquiry legal team disagrees with the provisional redaction, although we hope that such an occurrence would be rare. That said, where this does agree, and we disagree with the material provider, we envisage that the material provider would then, in short order, be required to make a bespoke restriction order, which you, sir, would then determine. In this scenario, and any other scenario where there is not complete agreement from the inquiry legal team over material which a provisional restriction order is sought, falls squarely within one of the two pre-approved categories, then a bespoke restriction order would be required. Finally, sir, if it is asserted by a material provider that a document or content of a document is so sensitive that it cannot be disclosed to a core participant, then there will be the opportunity for that to be addressed through a closed restriction order process, which will be set out in due course. Through that process, a material provider's assertion of such would be rigorously tested. And finally, sir, it goes without saying that there remains always the opportunity for core participants to apply for bespoke restriction orders for circumstances which do not fit either of the recognised models. Turning then, sir, to stage 2 of the process, the disclosure of operationally sensitive material. Once a document has been identified as containing operationally sensitive material, the provisionally redacted version of the document will be made available to core participants in the normal area of the Relativity online disclosure system and would be treated like any other document. That version of the document will be referred to as the open redacted document. But core participants will also have access to an operationally sensitive material area within the disclosure platform. That area will contain documents with the relevant operationally sensitive content visible. This version will be known as the operationally sensitive document, or OS document. That document will be marked with the words operationally sensitive, and the redactions will be marked with a box containing the watermark operationally sensitive. Those documents will only be disclosed to specified individuals, including core participants and their legal representatives, and the accompanying restriction order places some proportionate limitations on the handling of those documents, including, for example, that they will not be capable of being downloaded or printed, no screenshots or images of those documents will be permitted. Turning then, sir, to stage 3, the use of the material. We recognise that access to the documents through stage 2, as I've outlined, is but the first step, and that core participants and the inquiry must be able to use these documents effectively in inquiry hearings and submissions. Importantly, sir, I should say that nothing within the operationally sensitive restriction order process is intended to inhibit or limit core participants' ability to ask Rule 10 questions or make submissions about the open, redacted document in any open hearing without any additional restrictions. The restriction order and process that we propose relates only to the operationally sensitive material and provides that any questioning about that material would occur during what we have described as a restricted hearing. The following individuals would be permitted to attend such a restricted hearing: the inquiry legal team and inquiry support staff, core participants and their legal representatives, relevant witnesses, accredited media, and anyone else, sir, that you authorise in writing. We consider that it is appropriate and necessary to set this default process explaining who may attend a restricted hearing. This, we suggest, has the benefit of ensuring consistency and managing expectations. We recognise that in exceptional circumstances, it may be necessary to adopt bespoke arrangements which can be addressed on a case-by-case basis. But that possibility does not, we say, detract from the benefits of agreeing a default process, which it is reasonably expected to deal with most, if not all, situations. A restricted hearing to address operationally sensitive material would, of course, only be necessary if, on cogent grounds, the inquiry or core participant required questions to be asked of a witness about the operationally sensitive material. Of course, we anticipate that some restricted hearings may be inevitable, but we believe that in many cases, steps can and should be taken to make them unnecessary. In particular, legal representatives may be able to frame questions so as to remove the need for the question and answer to refer directly to operationally sensitive material. Of course, a restricted hearing would only be necessary if these methods were insufficient to allow the relevant evidence to be presented or tested appropriately. Finally, sir, in relation to restricted hearings, the disclosure, sharing or publishing of anything said in a restricted hearing would be prohibited by the restriction order, and the hearings would not be broadcast through YouTube. However, sir, as I've said, accredited media would be entitled to be present at any restricted hearing and would be able to apply to you, sir, for permission to report on the evidence that has just been heard during a restricted hearing. You, sir, would then make a ruling on any such application, having invited submissions from any core participants with a direct interest in that issue. So that, I believe, explains the process that we propose to ensure that operationally sensitive material is identified and handled fairly so as to avoid disproportionate delay to the progress of your inquiry. Can I turn finally to address some specific issues that arise from the core participant submissions which have not already been addressed? Turning first, sir, to the submissions filed by the bereaved families and survivor core participants. These submissions, we are grateful, all acknowledge the carefully balanced process that we have set out in our note and submissions. In particular, we are grateful for the indications that in general the bereaved family and survivor core participants consider that our proposed approach demonstrates as much openness and transparency in this process as possible. We are grateful to Fox Law for their observation that the procedure we set out in our note did not expressly state that core participants will have the opportunity to challenge a decision that material is operationally sensitive, whilst also recognising that a challenge is unlikely. Integral to our process is that all operationally sensitive redactions applied under this process are provisional, because they will, of course, as you would expect, be kept under review during the life of the inquiry and may fall to be removed, amended if further information is identified about that redaction. Further, and in any event, any core participant who wishes to raise an objection to material being classified as operationally sensitive has that opportunity. The starting point, we suggest, would be to raise that material with the inquiry legal team. And if the issue is not resolved in that way, as with any other aspect of the process, so you could be invited to resolve the dispute. Turning then next, sir, to the submission from HMG, which raises concerns about whether the proposed approach is appropriate or practical in the circumstances of the inquiry. As both Mr. Greene and I have said at the beginning, we understood recently that most, if not all, of the concerns raised by HMG are no longer pursued. Nevertheless, sir, we consider it appropriate to address the issues raised in written submissions in an open hearing. In their submissions, HMG suggested that any attempt to draw a bright line distinction between closed material and operationally sensitive material may not be feasible in the circumstances of this inquiry, where operationally sensitive material, they suggest, may be very sensitive indeed, and where disclosure of material in general has the potential to cause a high degree of harm. We do not accept that HMG's concerns are well-founded. We consider that the categories-based approach that we've established is both lawful, necessary, and proportionate methodology for protecting this operationally sensitive material. The HMG written submissions made the point that there may well be operationally sensitive material which cannot be disclosed, even subject to confidentiality undertakings, given the sensitivity of any harm involved. Our process already envisaged a range of measures which negate all of the concerns raised by HMG, which, as I've said, we consider not to be valid. First, the operationally sensitive restriction order process is only designed to apply to material that can be disclosed to all court participants, but which is not capable of being made public without redaction. It is not, and never was, intended to apply to materials that are said to be closed because those materials engage matters of national security. A separate note will be circulated in due course on the proposed approach to handling of closed material and the process for seeking restriction orders in respect of such material. If HMG perceive that any particular document or text is so sensitive that it cannot be addressed as operationally sensitive and can only be addressed through the closed process, then they would of course be able to indicate this. Second, we would expect that any material which is asserted to be closed on the basis that it engages matters of national security would not have been provided to us through our open disclosure platform, and accordingly, material which might engage this issue, we suggest, should be easily identifiable. Accordingly, sir, we do not accept HMG's written concerns about the value or utility of this process. There is unquestionably material which we hold, which falls to be disclosed to court participants, but which is not capable of being made public without redaction. It is for this material that this process is intended. If there is material which is so sensitive it cannot be disclosed for national security reasons, that can be addressed through the closed restriction order process to be set out in due course. If neither process is appropriate, there remains, as with any aspect of the inquiry's work, an option for core participants to make bespoke applications to manage any difficult or unforeseen circumstances. Finally, sir, turning to the submissions from the BBC, which again we understand this morning have fallen away. The BBC suggested in writing that the proposed prohibition on the publication of anything said in an operationally sensitive material, unless permission was sought and granted from USA, amounted to an inversion of the open justice principle. Again, we do not agree. The starting point is that accredited media are able to attend the whole of an operationally sensitive hearing. The rebuttable restriction on publication of anything said in an operationally sensitive hearing is essential to give effect to the operationally sensitive restriction order. It applies only to material which has been the subject of an assessment that its content is sensitive and falls within one of the two predetermined categories. Whether the publication of a discussion about that material in an operationally sensitive hearing would in fact reveal sensitive information can only safely and properly be made in light of consideration of what is actually said in the hearing. It would be illogical and contrary to the purposes of the restriction order for the media to be able to report contemporaneously anything said in an operationally sensitive hearing. The process we propose for an operationally sensitive hearing is not novel or groundbreaking. Indeed, similar processes operate in numerous other inquiries and sensitive hearings where there is a risk or likelihood of sensitive material being mentioned. It is envisaged, sir, that at the end of an operationally sensitive hearing, you would, either on your own motion or by application from the media, indicate which parts of the hearing can or cannot be reported. And experience would suggest that this is an entirely collaborative process which rarely results in any challenge. So that concludes all that I wish to address you on, and we invite you, as I say, to endorse the proposed process for handling and disclosing operationally sensitive material as set out in our notes and submissions, and to issue the final operationally sensitive restriction order which facilitates that process. The proposal now, as Mr. Greenie set out, sir, is to hear first from HMG, then from PSNI, and then from the BBC, and then to hear from any of the bereaved family and survivor corps participants who wish to make submissions. Sir, unless I can assist you any further.
Thank you, Mr. Pleath. That's most helpful.
And so we would therefore invite Ms. Fee to come forward and to make any submissions that she wishes to make.
Good morning, Ms. Fee.
Good morning, sir. Thank you. Sir, as you know, I act on behalf of His Majesty's Government. I'm assisted today by Junior Counsel Mr. Reid, and I'm instructed by the Government Legal Department and the Crown Solicitor's Office. I wish to say at the outset, sir, that HMG is grateful to the inquiry for what has clearly been a careful and thorough consideration of the written submissions made by HMG and indeed by all corps participants on the difficult issue of operationally sensitive material. As I will explain, the inquiry's helpful recent note dated the 4th of November 2025, clarifying and refining the proposed procedure, has answered many of the questions posed in HMG's written submissions and has alleviated key concerns. As the inquiry is aware, HMG has been working diligently to progress disclosure and has been working closely with the inquiry to ensure that relevant material is provided as efficiently as possible, with a significant volume of material provided to date. HMG recognises the challenge which the inquiry faces in analysing and processing large volumes of material, some of which is not capable of provision in open. And HMG accepts that clear, robust and effective processes for dealing with disclosure are in the interests of all corps participants. The inquiry has HMG's detailed written submissions on the proposed process set out in the inquiry's note dated 29th of August 2025. This process, of course, relates to material which is not capable of being made public without redaction due to its operational sensitivity. And at paragraph 2 of its August note, the inquiry described that material as material which, if published, would alone be capable of assisting those who would wish to carry out future terrorist attacks or other criminal activity, and or would, in combination with other material already in the public domain or contained within other disclosure, be capable of assisting those who would wish to carry out future terrorist attacks or other criminal activity. The inquiry's August note proposed dealing with operationally sensitive material in a manner different to other sensitive material, and HMG's written submissions dated the 6th of October 2025 raised a number of questions and concerns about how the proposed process would work in practice. Many of those questions, sir, have been helpfully answered by the inquiry's recent note from October 2025. The inquiry has explained at paragraph 9c of its November note that material providers or those with equity in the content will indicate in their review of materials whether they agree with the identification of the operationally sensitive material and whether any other information within a document is considered to be operationally sensitive and to require redaction. The inquiry explains that through this process, the material providers are able to identify material which they consider unsuitable for the operationally sensitive process. And helpfully, the note explains that if the ILT disagree with the material provider's assessment, then, as with any aspect of the process, there remains the opportunity for applications to be made to the chairman for a bespoke approach. HMG's concerns about the use of the phrases official sensitive, which is explained at paragraph 10 of the written submissions, and in the public domain, which is at paragraph 11, have also been helpfully addressed in the inquiry's November note. In short, HMG's concern about the principle of seeking to draw a bright line distinction between operationally sensitive and closed material is considerably alleviated by the potential to apply to the chairman for a bespoke approach should it be necessary in some specific instance. Similarly, the refinements proposed by the inquiry in its November note in relation to the wording and formulation of the proposed categories have helped to address HMG's practical concerns about the working of the process. HMG has given careful attention to the written submissions of the families and core participants and the inquiry's November note, and does not now propose to take up any further time at this hearing by rehearsing the points made in the October submission. The difficulty of the issue is recognised by HMG, and thanks are again extended to the inquiry for its careful consideration of all of the written submissions and its helpful note in response. Thank you, sir.
Well, thank you for your constructive approach, Ms Fee.
So could we next invite Mr Henry to make any submissions that he wishes to make on behalf of PSNI?
Good morning, Mr Henry.
Good morning, my Lord. I'll be relatively brief. As you know, I appear on behalf of the PSNI, attended this morning by Ms Kelly and assisted by Mr Thompson. We approached this issue by agreeing in principle with the value that it would add to the inquiry, and also in an attempt to be helpful, we made a number of constructive suggestions which I'm grateful to have learned were considered carefully, not only by the inquiry legal team, but also by my learned friends who appear for the various court participants. And the suggestions that we have made have been taken up and incorporated. The only change, therefore, sir, which has manifested since we provided our written submissions is the new form of words for the combined or merged category, and we've no issue with that form of words at all. So that's all I would like to say this morning, other than to extend our thanks to, again, to my learned friends, for the court participants, and also to the inquiry legal team.
Thank you then, Mr Henry.
Thank you.
So next on the list is Ms Smith on behalf of the BBC.
Good morning, Ms Smith.
Good morning, sir. I appear on behalf of the BBC this morning, instructed by Carson McDowell, solicitors, sir. At the outset, the BBC would like to note that it is recognised that at the core of the written submissions certainly made by the families, that there is a desire for delay to be minimised in these proceedings, and by extension for a pragmatic approach to be taken to issues that could potentially cause delay. In that context, it's important to state that the BBC intends to work collaboratively with the inquiry, and where issues do arise, we will aim to resolve those issues in a manner that avoids any unnecessary delay to proceedings. Sir, these remarks will happily be relatively brief, as notwithstanding the concerns expressed in our written submissions, as a result of the clarification and refinement brought by way of the updated inquiry legal team note, the BBC can indicate that, broadly speaking, it does not oppose the final order in the terms proposed by the inquiry legal team. However, as a result of a number of the remarks made this morning by the inquiry legal team, insofar as it characterised the submissions of the BBC, it is important, first of all, to clarify what the BBC's position was. Dealing first with the categorisation of official sensitive material. In the first instance, it will have been clear from the outset that the BBC does not oppose the restriction on reporting of official sensitive material in principle, and it was in fact content with the categorisation of material that would fall within the remit of the order as initially proposed by the inquiry legal team. In this respect, it was the submission of HMG and the PSNI that caused concern for the BBC, and in particular the concerns that were raised in respect of the concept of the public domain insofar as it may affect the description of Category C material. The BBC made the point that the concept of the public domain is one that is applied regularly by courts and tribunals when asked to consider the imposition of an anonymity or restriction order. It is well settled law that whether information is already in the public domain is a highly material factor which can weigh against the imposition of a reporting restriction. Whilst the BBC is now content with the inquiry legal team's amended approach, whereby the chairman will endorse the principle that when consideration is being given at any stage to whether material should be deemed officially sensitive material, a relevant consideration in that decision is the degree to which there is already awareness of that information. It should be noted that the content of the submissions made by HMG and the PSNI remain a matter of concern, in particular in so much as they alluded to the idea that journalistic material may indeed nevertheless fall outside matters that is considered to be material in the public domain already, and point to the need for the inquiry when conducting this exercise to pay particular and cautious attention to any submissions made by the parties in that respect. In addition, from the BBC's perspective, and certainly probably from the media at large, insofar as material already in the public domain may be deemed to fall within the scope of the order, it must be clearly confined, this order, to material that is derived from official sensitive material documentation shared with the inquiry and must be prospective in nature. It should not, for the avoidance of any doubt, capture any pre-existing publication of material that is already in the public domain, including, for example, archive material or the inadvertent republication of that material. Sir, the primary concern of the BBC in respect of the approach to be adopted to operationally sensitive material was the approach that was proposed in respect of the reporting of material of matters that had been outlined in the course of an operationally sensitive hearing. It has been suggested to you twice, at least this morning, that the BBC had initially contended that it should be permitted to report contemporaneously from an operationally sensitive hearing. So that submission has never been made by the BBC. Rather, the concern was how the issue of reporting restrictions should be determined following an operationally sensitive hearing. The BBC was particularly concerned with the proposal that the inquiry intended to prohibit the publication of anything said in an operationally sensitive hearing unless permission was sought and granted by the chair by those who sought to report on it. The BBC had pointed out that the inquiry had no means of knowing how any particular witness would respond to questions posed in advance, and it appeared to the BBC certainly that it could not be said that everything said or anything said in the course of an operationally sensitive hearing would necessarily disclose the operationally sensitive material at issue. It seemed to the BBC, and it appears to be agreed by the inquiry legal team this morning, that that is a question that can only be determined based on the particular facts of a specific hearing on the day. The primary concern was, however, that, contrary to legal authority, the burden was being placed not on the party seeking restriction to persuade the inquiry that it was justified to make such an order, but instead on the media to apply for permission to report on anything said, even if what was being sought to be reported on did not disclose the official sensitive material at issue. Operationally sensitive material, I apologise, Chair. The approach contained within the inquiry legal team note, in our position, rendered restriction the default position and required the media to discharge the burden of demonstrating why open justice should be restored in relation to those specific matters that it sought to report. As a result of the clarification and refinement of this position brought by the recent updated note of the inquiry legal team, we have now been advised that it is in fact envisaged that at the end of any operationally sensitive hearing, the chair himself would either, of his own motion or on the application of those present, indicate which parts of the hearing can and cannot be reported openly. It is in light of this clarification that the BBC no longer takes issue with the proposed approach to be adopted to reporting. The position, it appears now, where the chair will himself consider of his own motion whether what matters can and cannot be reported to be in keeping with principles of open justice and to facilitate the timely reporting of matters in the public interest where reporting is permitted. The BBC looks forward, as I've indicated, to working collaboratively with the inquiry if and when issues arise, but it is indeed hoped that issues will not even arise in the first instance, given the stated commitment to avoiding operationally sensitive hearings wherever possible. Unless I can assist the Chair, those would conclude our submissions.
Thank you, Ms Smith.
So we will try to finish topic 1 before we take a break, if that would be convenient to you. And that means that we turn next to any submissions that those representing the bereaved families and or survivors wish to make. And we will invite Mr Southey first of all to make his submissions.
Thank you. Chair, I have some very brief remarks to make. On behalf of the call participants that I represent, we firstly welcome, obviously, the fact that agreement seems to have broken out and there is, as a result, a pragmatic approach agreed. In that context, we thank the inquiry legal team for its hard work in seeking to come up with a pragmatic approach. We agree with what I think was said this morning, that it is important that issues like this do not become a distraction. There are just a couple of brief things I would want to say. Firstly, I just want to emphasise again one thing that was clear from the evidence of the core participants who I represent at the commemorative hearings and the evidence at those hearings more generally. Two principles we submit came across absolutely clearly from that evidence, or two matters came across absolutely clearly from that evidence. Firstly, core participants want to ensure that issues are fully investigated. As was said, they feel this is likely to be their last opportunity to get to the truth. That is relevant because an important part of that of this process that will ensure that matters are fully investigated are that core participants should be able to participate as fully as possible in the process. Secondly, it's also important that delay is avoided. That's important as there's clearly a need to ensure that any procedure doesn't result in delay. Overcomplication can create delay. In light of this, we welcome the note, particularly the one dated the 4th of November 2025, prepared by the inquiry legal team. It appears to us the two notes from the inquiry legal team seek to reflect the principles and concerns of the core participants that I've just identified. In particular, we agree it's important that core participants see material as soon as practicable, as was said in paragraph 2b of the note of the 4th of November. That minimises the risk of delay and ensures that core participants can play their role as soon as possible. It also recognises that core participants are in a different position to the general public, not least because of the undertakings that they have offered. We also welcome what is said at paragraph 7 of the note, which is that parties will be able to object to the treatment of material being treated as operationally sensitive. We always assumed that was a case. We always assumed that was the case, and obviously core participants do have an important role to play in testing whether or not material can be made public. Ultimately, the core participants do want as much public as possible. One issue that I should highlight that we have been able to discuss this morning, in fact, with the inquiry legal team, is a concern we had about the earlier note dated 29th of August 2025, where it was said cogent grounds need to be identified before a witness is questioned about operationally sensitive material. We always understood that this was intended to be to link effectively to what was said at paragraph 36 of that note, which is that questions should, as far as possible, essentially be asked in a manner that avoids the need to reference operationally sensitive material. That seems to us important, and we have no objection to that. However, our concern about the reference to cogent grounds was that we wanted to make it clear that we understood that not to mean that there was some different test, essentially, to relevance of issues, essentially, where those issues were based on operationally sensitive material. Whether or not an issue is based on operationally sensitive material cannot, in our submission, change the need for full investigation of that issue if it is relevant. Having now spoken to Mr. Greene in particular, we understand that our understanding of what was said about cogent grounds is correct, and it is not suggesting that there is some different test to the relevance of issues. It is simply an indication that, as far as possible, people should avoid referencing operationally sensitive material so that as much as possible can be investigated in open. Thank you.
Thank you then, Mr. Southey.
So thank you, Mr. Southey. And so to reassure him and reassure everyone else, the view of the inquiry legal team is that there is a single test for relevance and not some different test to apply to the operationally sensitive material. Could we next please invite Mr. Kane to make his submissions on behalf of the bereaved families and survivors that he represents?
Good morning, Mr. Kane.
Good morning, sir. Very briefly, having regard to all that has taken place since the original written submissions were made, can I just say in general terms, in respect of the clients whom we represent, we would reiterate our clients' desire, as we expressed in our opening statement, that within the context of the inquiry, the imperative must be that there will be full and open disclosure of material, in recognition of the need for as much open material as possible to be disclosed to the bereaved families and injured survivors as core participants. That should be the starting point and should not be deviated from unless there is clear and compelling reason established with evidence for material to become closed or restricted. And we have strongly already urged the inquiry, and we repeated that in our written submission, that when applying the relevant test, that the inquiry should take a robust approach in support of the interests of the bereaved families and injured survivors, and to disclose material or parts of material whenever it is possible to do so. And again, we reiterate that finely balanced judgments which have to be made should fall in their favour. And we were happy in the initial note from the inquiry legal team at paragraph 5 to read that there was recognition and acceptance of the wishes of the bereaved families and injured survivors as core participants, that they should have maximum access to relevant material. And indeed, we welcomed the indication that their concerns were held in due regard. Then very briefly, sir, arising from the submissions which were made in writing, can I just make one or two very brief points. As far as His Majesty's Government's submission was concerned, we reiterate what we said in a written submission, that the statutory powers given to you, sir, as chairman, under the Inquiries Act, ensure that all relevant material is subject to your perusal, subject, of course, to any objections raised by any core participants. And we note the similar view taken now by all our family representatives, and that it is shared by the inquiry legal team as they stated in their updated note at paragraphs 7 and paragraph 11. Likewise, in paragraph 6 of the HMG submission, where there is concern about a bright line, as it was described, being drawn between closed material and operationally sensitive material, we also welcome the approach which now has been taken by the inquiry legal team and which is not being dissented from at paragraph 8 of the updated note. Continuing on, we did in our written submissions urge the inquiry to resist the suggestion from HMG at paragraph 9 to introduce a new non-statutory definition based on sensitivity. And again, we welcome the resistance of the inquiry legal team on that issue, as they have explained at paragraph 10 of the updated note, and we consider that wholly appropriate. On the issue of material in the public domain, we highlighted again this as a potential problem, and having indicated the need for clarification on that issue, we did express an option within a binary context, but again, sir, we are content with the solution now being suggested by the inquiry legal team and the approach being adopted at paragraph 27. HMG at paragraph 11 regretfully used rather extreme language about what they described as rampant speculation. We felt that this introduced the possibility of legitimate issues being dismissed through some form of deflective criticism. On the behalf of the families whom I represent, we considered that such subjective and dismissive terminology as a crutch, as it were, to resist providing the disclosure sought by the Omagh families ill-served His Majesty's government, and indeed tended only to deepen any suspicion which the Omagh families might have as to the degree of readiness that HMG is demonstrating to properly assist and cooperate with the work of this inquiry. However, we do welcome now the recognition on behalf of the government that this approach should not be pursued, and an acceptance now of the position set out by the inquiry legal team as a proper way forward on this issue. Other than those remarks, sir, we have no other observations to make. We are pleased to support the updated inquiry legal team paper, and we extend our thanks to them for the work which they have engaged in, and indeed to all our parties in reaching an accommodation and an agreement which hopefully will prevent any delay and assist in our joint purpose in moving this inquiry forward.
Thank you, Mr. King.
So next we'll hear from Mr. Mansfield on behalf of the Rush family.
I just ask permission, if I may, to remain seated.
Of course, Mr.
Not
Mansfield.
out of disrespect for what's been said. There is a reason. I don't have anything to add other than to say thanks to your team. We support all that's been put forward, as we did in writing, so I don't repeat that. And we particularly welcome what I'm going to call a convergence of agreement. Thank you.
Thank you, Mr. Mansfield.
And so that means that finally we will hear from Mr. McGuckin if he has any submissions on behalf of the bereaved families and survivors that he represents.
Good morning, Mr. McGuckin.
Good morning, Chair, and thank you. I appear on behalf of the court participants represented by P.A. Duffy, Campbell and Holly and Roach McBride, as you know. You have our written submissions, which I know you have read. By virtue of that, you'll be aware that our submissions are aligned with your inquiry team and virtually the same as the CP victims and survivors teams that have preceded us. So I adopt those submissions, Chair, and I will provide a brief précis of what we state. Our position centres on one principle. The inquiry must be able to work in the open as much as permissible while maintaining a structure that is practical, fair and efficient. It is our belief that the inquiry team's proposal for handling operationally sensitive material achieves that balance, and we are heartened by the government's constructive approach that will no doubt alleviate many of the concerns our clients held in regards to their suggested approach. We respectfully endorse the inquiry model on foot of it meeting three essential requirements, we say, Chair. Firstly, it preserves openness as the starting point. It accepts that operational sensitivity is real, but it does not allow that concept to become a catch-all barrier or to be bled into the closed material category. The approach aligns with Sections 17 to 19 of the 2005 Act and with the principles reflected in the authorities that openness is the default but is subject to context and risk. Secondly, but of the utmost importance, we believe the inquiry model avoids unnecessary delay. And thirdly, fairness requires that in open, core participants see the same evidence the inquiry sees, subject to limited, proportionate redactions, and the inquiry model meets with that requirement positively and fairly, and with CP engagement when necessary. We respectfully say that the inquiry approach draws a clear and defensible boundary. Closed material remains subject to its own established process. Operationally sensitive material is managed through a structured system that protects the public interest without sacrificing transparency or participation. And we extend our gratitude for the inquiry's thoughtful approach in relation to this. As has been previously submitted, and to finalise, Chair, the families we represent want an inquiry that moves at pace, engages openly, and commands public confidence. And we believe that the inquiry's model will achieve that equilibrium. Thank you.
Thank you, Mr McGurk.
So I believe that we have now heard from all of those who had made submissions in writing. I'll be corrected if I'm wrong. So finally, may we thank the bereaved family and survivor corps participants for their support throughout the course of this process. And we'd like to thank also the State Corps participants and the media for showing flexibility of response and not simply entrenching. Where we seem to have reached is as follows: that all either support or at the very least do not oppose the proposed process for handling and disclosing operationally sensitive material, including the categories of such material described by Mr. Pleath. And furthermore, all either support the making of the final operationally sensitive restriction order, which facilitates the proposed process, or again, at the very least, do not oppose it. And we would therefore invite you in due course, if, sir, you also agree, to provide a short ruling explaining why and to make the final order. The interim order will remain in force until you do so. So, sir, at this stage, unless you have anything that you would wish to ask, we would invite you to rise and we'll take a short break before turning to the second topic, namely an update on Chapter 3.
Yes. But before doing that, Mr. Greenie, I think I'd like to observe that the hearing today, which has concerned how to effectively and expeditiously manage significant quantities of documentation, is one in which might otherwise, and in the absence of a working process, have impacted on the inquiry in a very demanding and challenging way. But the collaborative approach taken by all participants today appears to have led to an agreed outcome which will enable the inquiry to adopt an effective and a practical approach and to proceed with disclosure of the material under discussion. And that outcome appears to me to demonstrate the value of the process of written submissions, exchanged and then revised with a constructive approach and with an open mind. And that is a model which, having shown success today, might be utilised if necessary to address any future issues. And I think we've seen that's a course which we should give consideration to adopting in the future.
So thank you very much, and we agree.
As you suggest, I'll deliver a ruling in writing on the issue in due course.
Yes.
Shall we rise and sit again in about 15 minutes or so?
Yes, please, sir.
Mr De La Porte.
So, good morning. Chapter 3 of the inquiry's oral evidence hearing is entitled The Bombing of Omagh. It will be focused on the events immediately surrounding the bombing on the 15th of August 1998. As the inquiry legal team's note published on the website in March of this year explained, Chapter 3's purpose is twofold: to examine how the bombing was carried out and to develop an understanding of who was involved. Before turning to the way in which the Chapter 3 evidence will be structured, it is worth briefly explaining why Chapter 3 has the purpose it does. The inquiry's terms of reference require an answer to one question: could the detonation on the 15th of August 1998, which killed 29 people and 2 unborn children and injured so many more, have been prevented by the UK state authorities? Prevention, in this context, is not an abstract idea, but a real-world question focused upon whether those people responsible for the atrocity could have been disrupted at any stage up to the point of detonation. That, ultimately, sir, is the issue which your report will address and make findings of fact in relation to. And so, a necessary part of answering the preventability question is to understand which people were responsible for the bombing. Possessed of a provisional understanding of this, the inquiry will be able to investigate events before the bombing and consider what, if any, opportunities there were to disrupt those people. Connectedly, one way better to understand who was responsible is through the methodology used to carry out the bombing. By methodology of those who carried out the bombing, we mean to include the way the bomb was constructed and its components, the communication between those people as the bomb made its journey north, the approach taken to transporting the bomb, and the warning calls, as they have sometimes been described, which were made. Once established, these elements can be compared with previous terrorist incidents with a view to identifying earlier terrorist activity in which that same group engaged. As such, a key component of Chapter 3 and an important step towards understanding who was involved will be examining how the bombing was carried out. This knowledge will allow focus to be brought on the previous incidents which have been identified as being of potential relevance and which are listed in the provisional list of issues, an updated version of which was published on the inquiry's website on the 31st of October just gone. Chapter 3, sir, represents an important step within your investigation. However, we are confident that you will endorse the principle that no determination of fact will be made during Chapter 3 as to who perpetrated the Omagh bombing. Instead, what will happen is that evidence relevant to this issue will be led and, where appropriate, tested. By the conclusion of Chapter 3, a working hypothesis within this inquiry process of who was involved will, we anticipate, have emerged. That working hypothesis will draw on the evidence publicly presented during the Chapter 3 oral evidence hearings, which will include material prepared for the criminal proceedings and will build upon what was established during the Breslin civil proceedings. However, that working hypothesis will not be the end point. Rather, it will be kept under review as the inquiry progresses its investigation, and it may change should additional evidence emerge or later evidence justify reconsideration. It will form the starting point for the Chapter 4 phase of the investigation, namely the part of the inquiry's oral evidence hearings which will consider the previous incidents with a view to establishing which were carried out by those who were involved in the Omagh bombing what overt investigations took place into those incidents, what conclusions were reached as a result of that overt material, and what other steps, if any, ought to have been taken which would have led to the disruption of that group or any of its members before the Omagh bombing took place. Having set out what the objective of Chapter 3 is, we turn to provide some further detail in relation to the way in which the oral evidence hearing will be structured. What I'm about to say is not intended to be an exhaustive recitation of all of the evidence the inquiry will hear at this stage of its investigation, but rather is intended by way of overview. Core participants have received an inquiry legal team note in relation to the purpose, structure, and formalities concerning Chapter 3. What I'm about to say is intended to complement that note and increase public understanding about Chapter 3. The Chapter 3 oral evidence hearing will be divided into 10 parts. In Part 1, counsel to the inquiry will introduce the evidence which will be heard during this chapter. Part 2 will comprise introductory evidence, namely that relating to A, the attribution of key telephone numbers, B, evidence explaining how cell site analysis works and how this important technique can contribute to an investigation, and C, evidence introducing areas of forensic science relevant to the inquiry's investigation. Dr. Matthew Tart and Professor Angela Gallop will be called in relation to the latter two areas of evidence. Dr. Tart is an expert in cell site analysis. Professor Gallop leads a team of forensic scientists instructed by the inquiry and herself has a particular specialism in DNA evidence. Part 3. This part will focus on the period 12th to the 14th of August 1998, during which time the bomb car was stolen and prepared. In relation to any cell site evidence which may be relevant to this period, Dr. Tart will be in a position to assist. The events of 15th August 1998 have been divided into 3 time periods. The period before the first warning call, the period which includes the warning calls up to the point of detonation, and the explosion and its immediate aftermath. During Chapter 3, these time periods will be addressed by Parts 4, 5, and 6, respectively. In the course of Parts 4, 5, and 6, the inquiry will have the benefit of a hearing from 3 distinguished experts. Dr. Tart will be recalled to assist in relation to the important cell site analysis evidence, which, among other things, demonstrates the movement of the car containing the bomb across the border and into Omagh, and also reveals the existence of a second scout vehicle which accompanied the bomb car from the Republic of Ireland. Next, Professor Heather Hamill is an academic and expert in warning calls made in connection with terrorist activity. She will be called during Part 5, when other evidence relating to warning calls will also be heard. Finally, Hazel Hudson is employed by the Defence Science and Technology Laboratory's Forensic Explosive Laboratory and is an expert in explosives and bomb making. She has been instructed to assist the inquiry in relation to the construction of the bomb and its components. She will be called during Part 6, which will be the point at which the inquiry will be considering the explosion itself and its immediate aftermath. Part 7 will consider what the post-explosion investigations and processes subsequent to the bombing uncovered. We make clear that this will not be a review of the efficacy of these processes, as that would be beyond the terms of reference, but instead will identify information which arose from them and which may be of assistance to the inquiry's investigation. During this part, under the heading of the post-explosion investigations, we will hear from Professor Gallop and members of her team, who will assist in relation to the forensic science findings. Part 8 will be the point at which the inquiry hears about a number of important criminal and civil cases which arose directly out of the bombing or which may be of potential relevance to the inquiry's understanding of who perpetrated it. Part 9 will be concerned with terrorism legislation, which is or may be of relevance to the inquiry's investigation, including the timing and nature of legislative change, such as the specifying of the real IRA and the continuity IRA for sentencing purposes. Finally, in Part 10, the strands will be drawn together with a view to forming the working hypothesis of those who were responsible. Having provided an outline of the structure and having mentioned the expert evidence the inquiry will hear in Chapter 3, I will briefly draw attention to 3 other features of the evidence. First, the inquiry legal team is grateful to Angada Shiakana, the PSNI and the Ministry of Defence, all of whom have provided sequence of events evidence and presentational material on behalf of their organisations. This evidence will be adduced within the part structure I have identified. In relation to the Angada Shiakana material, Mr. Greenie will say something more about the inquiry's contact with the Government of Ireland in his procedural update, which will follow. In terms of the PSNI's sequence of events evidence, core participants have already had disclosed to them the very substantial work of Detective Chief Inspector Billingsley, supported, as I understand it, by a team. The other sequence of events evidence has recently been received by the inquiry and is in the process of being prepared by the inquiry legal team for onward disclosure to core participants. The second facet of evidence that I draw attention to is summaries of the detail of factual evidence which are being prepared by the inquiry legal team. These will be circulated to core participants before Chapter 3 with an invitation to make proposals for inclusion if required. Third, and in the same vein, the inquiry legal team is also preparing for circulation to core participants summaries concerning the many processes which followed the bombing and the legal cases to which I have already referred. Again, the inquiry legal team will invite the contribution of core participants to these documents. We are acutely aware that many core participants had direct experience of these processes and proceedings at the time, and indeed were involved. As has been said previously by Mr. Greenie, but which bears repetition in this context, the inquiry legal team values the contribution core participants have to make. The approach which has been adopted is intended to ensure that all relevant evidence is efficiently managed and accessibly presented, and for this we welcome all contributions from core participants aimed at achieving this goal. Finally, sir, may I conclude this update on Chapter 3 with 3 short observations. The first of those is this. The inquiry legal team is grateful for the support and contribution from all core participants in the preparation which has taken place to date. A lot of work has been done for Chapter 3, but there remains much still to do. My second concluding observation is this. Chapter 3 will commence on the 9th of March of next year. As that date approaches, the intensity of preparation will only increase. It will be important for all the deadlines that are set aimed at achieving this date are adhered to by all. Thirdly and finally, the Rule 10 protocol, published earlier this year and which can be found on the inquiry legal team's in the inquiry website, will be essential to the success of Chapter 3. As I've said, the protocol can be found on the inquiry website, and it sets out the process by which all core participants can apply to ask questions of witnesses if they wish to do so. So, unless there is any other matter that I might deal with to help you, that was all that I was proposing to say.
Thank you. I'm grateful, Mr. Delaporte.
So we'll deal finally, as I said we would, with topic 3, which is at a high level a procedural update. On the 2nd of October, so about 6 weeks ago now, the inquiry legal team provided its 8th update note to core participants. That note ran to 37 pages and it provided considerable detail. So what I'm going to say now will in large part not be news to core participants, but it's important that we should provide a summary of what we've done and where we are for the benefit of the public. And moreover, some of what we have to say will be new to core participants as well. The focus of what we have to say is on the work done by the inquiry to gather in the documentation that you, sir, need in order to fulfil your terms of reference. Since the inquiry was formally established, the inquiry legal team has issued a large number of requests pursuant to Rule 9 of the Inquiry Rules 2006 for the disclosure of material and evidence which may touch upon the inquiry's terms of reference and its provisional list of issues, which, of course, was recently updated. These requests have been made to core participants and to material providers, both in the United Kingdom and the Republic of Ireland. So we don't intend to detail every person or organisation that has received such a request, let alone describe the content of those requests, because to do so would require us to have that second day of hearing. Instead, what we'll do is simply provide an indication to the world at large of the breadth and scale of the work that has been undertaken. Comprehensive Rule 9 requests have been made of the Government of Ireland. That has included a request for the provision of materials for the purposes of the inquiry's work in preparing for Chapter 3 of its oral evidence hearings. As Mr de la Poer explained a few moments ago, this involves an evidence presentation focused on events within the Republic of Ireland that are relevant to the period from the 12th to the 15th of August 1998. And that will support similar pieces of work which have been prepared and provided to us by PSNI and by the Ministry of Defence. The Government of Ireland presentation and an accompanying narrative explanation have now been received very recently from the Government of Ireland. And so you and the core participants can be assured that we will continue to work with the Government of Ireland. We meet with their officials regularly to establish how their materials will be presented in Chapter 3 and how other Government of Ireland officials are to give evidence in due course. And we'll provide an update on those matters once we're able to. The Government of Ireland has also responded to other Rule 9 requests, although not yet completely, and has recently made regulations under its data protection legislation specifically designed to support the Omagh bombing inquiry. And we're grateful to the Government of Ireland for what it has done so far, but we have to add that there remains much work to be done. Turning away from the Government of Ireland, many Rule 9 requests, indeed I might say very many Rule 9 requests, have been made of His Majesty's Government in its various parts. We welcome the constructive dialogue that we have had with the legal team supporting HMG, which includes regular meetings to discuss progress on requests for disclosure and information. At the risk of stating the obvious, it's important that HMG, along with all material providers, should work to deadlines set by the inquiry and adhere to systems for disclosure established by the inquiry, particularly where such systems have been tried and tested in other processes. We're not going to seek to identify every part of the UK state to which requests have been directed, let alone detail every Rule 9 request or its content. However, what we can say is that requests have been made, often repeated requests of the following: the Home Office, the Cabinet Office, including the former chair of the Joint Intelligence Committee, the UK Intelligence Community, the Northern Ireland Office, the Foreign Office, the Ministry of Defence, His Majesty's Revenue and Customs, the Department for Science, Innovation and Technology, the Defence Science and Technology Laboratory, the DSTL, the National Crime Agency, the NCA, the Investigatory Powers Commissioner's Office, the UK Accreditation Service, the Forensic Science Service of Northern Ireland, FSNI, and the Intelligence and Security Committee of Parliament, the ISC. Furthermore, as will surprise no one, extensive Rule 9 requests have been made of policing or policing-related bodies. Many requests have been made of PSNI. We, the inquiry legal team, have worked closely with PSNI and its lawyers to ensure that the extensive disclosure that is required of it is progressed and that the most urgently required material is prioritised in accordance with our priorities. The relationship has been one of cooperation, and so, as you will recall, we have previously expressed our thanks for the surge in resources, as it was described, given by PSNI to support the work of the inquiry. However, as with HMG, the scale of the task cannot be overstated, and much work remains to be done. Furthermore, within the policing sphere, requests have been made of the following: the Police Ombudsman for Northern Ireland, the Northern Ireland Policing Board, His Majesty's Inspectorate of Constabulary, Fire and Rescue, the Metropolitan Police Service, Counter-Terrorism Policing Headquarters, the National Police Chiefs Council, the College of Policing, the National Source Working Group, Essex Police and Greater Manchester Police. And so pausing for a moment so that my submission doesn't become just reading out one long list. Those listening might wonder why requests have been made of Essex Police and Greater Manchester Police. And these are the reasons. It's widely known that there came a point in time at which mobile telephone numbers were attributed by the authorities to a number of those believed to have been responsible for the Omagh bombing and potentially earlier attacks too. We, your team, are determined to establish what the capabilities were within the UK state in relation to cell site analysis in 1997 and 1998, in order that we can then explore whether that tactic may have been utilised to expose the activities of the bombers before the Omagh bombing and disrupt their activities. And so this is just one of many strands of our work. To that end, we're investigating with Essex Police whether they utilised cell site analysis in their investigation into the murders of 3 men on the 6th of December 1995, murders that are sometimes referred to as the Rettendon murders or the Range Rover murders. And we are investigating with GMP whether they utilised that capability, cell site analysis, in their investigation into the provisional IRA attack on the Arndale Centre in Manchester on the 15th of June 1996. And so to complete the picture in terms of requests made pursuant to Rule 9 of policing bodies, a request has also been made of Merseyside Police in respect of the review that they conducted into the RUC's investigation of the Omagh bombing. And so, as you know, that is a review that was conducted by Deputy Chief Constable Michael Tong of Merseyside Police. Telecommunications, as I have just highlighted, is an important strand of the inquiry's work, and as a result, Rule 9 requests have been made of all relevant telecommunications providers in relation to relevant telecommunications in 1997 and 1998, and requests have also been made of the regulator Ofcom and of key individuals, and so we have had a good deal of cooperation in those regards. Requests have also been made of various archives and museums in order to ascertain whether they have relevant material, and if they do, to obtain it from them. And bearing in mind the other criminal civil and coronial proceedings that have followed on from the Omagh bombing, and to which Mr Dillapore made reference a little earlier, requests have also been made of prosecuting agencies and court bodies. Those requests have included requests of the Crown Prosecution Service in England and Wales. That request was in relation to the successful prosecution of men named Anthony Hyland, Darren Mulholland and Liam Grogan in 1999 in relation to a conspiracy to cause explosions in England in July 1998. Requests have been made of the Public Prosecution Service of Northern Ireland here in Belfast for materials relating to the prosecutions of names that will be very well known to people in this room, Sean Hoey and Seamus Daly. And requests have also been made of the Northern Ireland Courts and Tribunal Service and the Coroner's Service of Northern Ireland for reasons that will be obvious. Rule 9 requests have additionally been made of important individuals such as Kevin Fulton, and the inquiry is in touch with significant figures such as David Rupert, John Ware and Martin Bridger, and is taking steps to secure their evidence. Finally, while reminding everyone that while this list is long, it is not intended to be an exhaustive list, the inquiry has taken steps to secure evidence from the Northern Ireland Affairs Committee, so NIAC. And so we judge it's worth saying a little more about this particular request. Norman Baxter was appointed the Senior Investigating Officer for the investigation into the Omagh bombing in May 2002, following, as you recall, sir, a critical report by the Police Ombudsman for Northern Ireland. The inquiry is in touch with Norman Baxter. He has been very helpful and we are taking steps actively to secure his account. Norman Baxter gave evidence to NIAC on the 11th of November 2009. The transcript of his evidence reveals that in addition to giving evidence in public, he gave evidence in what was described as a, quotes, private session. In order to obtain access to a transcript of that private session, it was necessary for a petition to be presented to Parliament. On the 9th of July of this year, the chair of the Northern Ireland Affairs Committee, Tonia Antoniazani, MP, presented a petition to the House of Commons from Tim Souter, the solicitor to this inquiry, in which she asked the House to make arrangement to supply the inquiry with the unreported oral evidence taken by the Northern Ireland Affairs Committee on the 11th of November 2009, that is to say, the evidence of Norman Baxter. On the 14th of July, so very promptly indeed, the House of Commons ordered that the petition be referred to the Committee of Privileges, and the House set terms of reference for the committee in that regard. In due course, the committee made recommendations, including that the transcript that we were seeking be released to the inquiry. That was debated in the House on the 29th of October, so 2 weeks ago now, and the recommendation of the committee was adopted. And so I can say that happily the inquiry does now have the transcript of the evidence given in the private session by Norman Baxter. We believe that this is the first time the process we have described has ever been used, that the inquiry has been prepared to petition Parliament, notwithstanding the novelty and complexity of the process, in order to obtain relevant documentation is, we hope, an indication of the determination of, sir, your inquiry to obtain the materials it needs in order to fulfil its terms of reference. Excuse me. The upshot of all of that is that the inquiry has received what I hope I can describe without hyperbole, as a vast amount of documentation, which it continues to work through to identify that which is relevant, in order that that which is relevant can be disclosed on to core participants. So to put some numbers on that, to date, a total of nearly 4,000 documents have been disclosed to core participants in 14 tranches. That totals nearly 65,000 pages. It is, of course, an ongoing process, and it's also a massive process to which many within the inquiry legal team have made a significant contribution. So that's all we have to say about disclosure. We hope what we have said will be of assistance to core participants and of interest to the public at large. The last hearing before today, as everyone will recall, was convened, sir, to enable you to hear submissions on whether there is a power to appoint special advocates in a statutory public inquiry, and if there is, whether that power ought to be exercised in the circumstances of this inquiry, the Omagh bombing inquiry. And our understanding, sir, is that you anticipate being in a position to hand down your ruling on those issues at some stage next week. That concludes that all we, the inquiry legal team, assess that we need to say today. We will next door meet, unless anything unexpected intervenes, on the 9th of March next year for Chapter 3 of the inquiry's oral evidence hearing. And that hearing will take place at what will then become the inquiry's permanent home at Bradford Court. So thank you very much to all of those who have attended today and made a contribution to your process.
Thank you, Mr. Greenie.